So don't tell me I question your ethic. You're going to be found in contempt. I'm done, Ms. Toe. You took funds that would have been client funds and somehow took them into your possession to redistribute.
Their actions appear intended to harm my family financially.
Housing 401k plan versus Erica Ward.
Good afternoon, Your Honor. Steve Otherly on behalf of Plaintiff Fixing Housing 401k plan.
Good afternoon, Donna Tope on behalf of Erica and Aaron Ward. They are the tenants in this lease.
All right. Where are we now?
So, my understanding is after a long conversation that we had last Monday, that this hearing was held in anticipation of my action or interaction. And I would, if I filed a withdrawal, then the hearing wouldn't be held. And
If you filed I don't think I said that.
well, you didn't say it, no. But you said that if circumstances worked out the way you were suggesting, there were two choices, and that's why this hearing was being held. Do I not have it correct?
Yeah. Keep going.
Okay. So I'm here because I would like to make this statement to the court on the record. This case is a landlord-tenant case. I repeated that in our answer that was filed with this court. The lease is not a commercial lease.
The hearing opens with immediate tension as the judge warns the attorney not to misrepresent his concerns or risk being held in contempt. What begins as a landlord-tenant dispute quickly turns personal when questions about client funds and legal conduct enter the courtroom. The attorney attempts to explain the lease structure and property use in detail, but the judge repeatedly cuts in, signaling growing impatience as the courtroom atmosphere becomes increasingly hostile and unpredictable.
As plaintiffs and this mentioned several times, the lease is between an LLC landlord and a married couple, Erica and Aaron Ward. The lease specifically states the lease is for their use as an animal farm. The property is zoned agricultural and has been used lawfully for over 25 years as an equestrian center with several major outbuildings and one residential unit. This lease began in 2021, just 3.5 years ago. The lease terminates in 3.5 years from now. None of the land is zoned commercial. None of the property is used commercially.
Why are you telling me this now?
And the lease is not a commercial lease because several times plaintiff has referred to this as a commercial lease. And I heard this court repeat that this is a commercial lease. There are different standards applied to commercial property and commercial property that is leased.
All right, then all you have to do is say, without this long rendition, that you don't believe it to be a commercial lease.
Okay. Well, I felt I need to just restate what I had said in my answer. It didn't seem to have been heard. I have been associated with Erica Ward.
I hear everything. Now, whether I react to it becomes a whole different thing, but I hear everything. Go ahead.
Well, I have been associated with Erica Ward for over 3 years in consultation with me as a property manager through my solo-owned property management company. She consulted with me over these past couple of years over many serious, dangerous conditions the landlord had refused to repair. I gave her the City of Ann Arbor information required to be provided to tenants by landlords and the Michigan State University Law Center's information for tenants and landlords, both of which describe the right of the tenant to withhold rent and pay for necessary repairs for the health and safety and habitability of the rented property when the landlord has refused to make the necessary repairs. Our answer, filed with this court.
The attorney insists the property should not be treated as a commercial lease, carefully outlining the agricultural zoning and long-term residential use of the land. but the judge appears unconvinced and visibly irritated by the lengthy explanations. As the attorney presses forward about repairs, tenant rights, and withheld rent, the court begins challenging the legal interpretation itself, creating a tense clash between procedural argument and judicial authority inside the courtroom.
Had the circuit court case attached, which was filed in July 9th of 2025. The jurisdiction for our breach of lease case was with the circuit court. And our answer describes the necessary repairs the landlord refused to make since 2023, which is his duty under the terms of this lease for agriculturally zoned property.
You
Erica
can't
Ward.
have it both ways.
Hmm?
You can't have it both ways. If you're going to claim, and counsel, before you go on, I think you need to do your legal research. If you're going to claim that this is not a commercial lease,
Yes,
it's a 7-year lease,
yes.
then the obligations regarding repair change.
That, I think that would be something to bring up by the plaintiffs, to rebut what I'm saying.
The hearing suddenly escalates when the discussion shifts from lease disputes to accusations involving ethics and handling of funds. The judge forcefully denies personally accusing the attorney of misconduct, while warning that unethical behavior would immediately be reported to the Grievance Commission. As the attorney pushes back, the judge's patience snaps completely. The confrontation peaks with a direct contempt warning, transforming a civil hearing into an intensely personal courtroom showdown.
Erica Ward asked me to be her attorney in the middle of July to file a complaint with the court over the landlord's waste and interference with her use of the property, which had caused her damages. This complaint was filed
I don't know why I need to know all of this.
because, Your Honor, you have questioned my ethical ability
I
to
have not
represent.
requested, I have not. What I have said is that if indeed you took funds that were the landlord's funds, the capacity that you're operating in is going to be a problem, counsel. That is what I indicated. If you don't see it as a problem, then so be it. But I think on its face, it's a problem.
After the contempt warning, the judge narrows the focus to one critical issue: why funds connected to the tenants allegedly passed through the attorney's possession. The attorney attempts to clarify that she acted only as a property manager during those events, not legal counsel. But the judge repeatedly emphasizes how the situation appears from the bench, making clear that perception alone can raise serious concerns. Every answer seems to deepen the tension instead of resolving it.
Any question regarding your ethics is your own. Because I'll tell you right now, if an attorney comes before me and I think that they have done something that I can show that they have done unethical, you will be reported to the Attorney Grievance Commission in a minute. So I did not do that. So don't tell me I question your ethics. I question the question. You know what? I don't need the dramatics. Any more dramatics, you're going to be found in contempt. I'm done, Ms. Tobe.
Yes. Yes.
What I said to you and what I was indicating is that you took, as you stand before me, the wards are your clients.
The final minutes become a battle over reputation, public record, and courtroom authority. The attorney warns that statements made in court carry consequences because the hearing is public and circulating online. The judge answers sharply, insisting the court merely express concern rather than formal accusations. In a closing exchange, the judge firmly ends the argument, stating that if actual unethical conduct existed, removal from the case would already have happened. Like the video, subscribe to the channel, and we'll see you in the next video.